Hi, everybody. Hopefully I've got it set up so that we can just go straight to the next few paragraphs of Michael Cicchini's excellent article that he wrote for the Oklahoma Law Review. I believe it's here. Don't know, that's not it. Here we go. That was piano music. But here is the next part of the this is where we got to last time. Section 1, paragraph 1, curative instructions. For many types of improper arguments, a curative instruction is potentially helpful. For example, assume a prosecutor misstates the burden of proof by arguing that because the state's evidence is more believable than the defendant's, the jury must convict. In this case, a curative instruction from the court may eliminate any prejudice. Such an instruction could remind jurors that the burden of proof is not the preponderance of evidence, and that if the jury has a reasonable doubt, then it must find the defendant not guilty, even if it thinks that the charge is probably true. However, even assuming the trial judge was paying attention to the prosecutor's argument and is also well educated on the law, devising an effective curative instruction on the spot in the middle of closing arguments is not an easy task. Thus, when trial judges sustain objections, they typically resort to the generic mantra that the words of the attorneys are not evidence and must not be considered by you as evidence. But this type of curative instruction doesn't actually cure anything. Rather, there are at least 3 problems with it. First, the instruction lumps both attorneys together, even though it was the prosecutor, not the defense lawyer, who committed the misconduct. Second, the instruction does nothing to identify the prosecutor's remarks as improper statements that should be disregarded. And third, telling the jury that arguments are not evidence completely misses the point, because the issue was not the introduction of improper evidence, but rather the impact of improper argument. Even a good curative instruction is not always sufficient. Some types of improper argument may be too clearly prejudicial for even a well-crafted curative instruction to mitigate their effect. For example, when a prosecutor argues, directly or indirectly, that the defendant's failure to testify is evidence of guilt, any curative instruction would likely serve to emphasize the improper argument rather than mitigate it. Similarly, when the prosecutor inflames the jury's passions by arguing that if they failed to convict, the defendant could victimize them or their families, even the best curative instruction cannot unring the bell. Mistrial, which of course is the name of the band that Rob Bellin plays in. Not to be confused with the band that Brad Schimmel and Sweaty Boy used to play in. That was called Alibi. Mistrial. In cases where a curative instruction is of little or no value, defense counsel can alternatively request a mistrial, but whether to grant a mistrial lies within the sound discretion of the trial court. One mistrial framework, for example, requires the trial judge to assess the impact of the prosecutor's improper argument on the trial as a whole by weighing the following factors. 1, the nature and seriousness of the prosecutorial misconduct. 2, whether the prosecutor's statements were invited by conduct of defense counsel. 3, whether the trial court's curative instructions to the jury were adequate. 4, whether the defense was able to counter the improper arguments through rebuttal. And 5, the weight of the evidence against the defendant. Under this particular test, the case for a mistrial will be strongest when, in a relatively close trial, the prosecutor repeatedly made improper arguments, particularly if they infringed constitutional rights such as due process, the right against self-incrimination, or the right of confrontation. The case for a mistrial will be strengthened if the prosecutor committed the misconduct in rebuttal, particularly when the arguments were not invited by any improper argument made by the defense counsel. The case will be strengthened even further when the impact of the prosecutor's misconduct cannot be mitigated by a curative instruction, or when the judge gives an instruction not sufficiently tailored to the misconduct. But even when a mistrial is granted, the typical prosecutor will simply retry the defendant, often with a battle-tested and stronger case the second time around. Whether a prosecutor can retry the defendant relies on a common, if bizarre, test. The Supreme Court of the United States held that the defendant's double jeopardy protections only extend to cases where the prosecutor's misconduct was committed in order to goad the defendant into requesting a mistrial. Under Kennedy, therefore, if the prosecutor merely intended to harass the defendant, overreach, or obtain a conviction by improper means, the prosecutor is rewarded by being able to retry the defendant in a second trial or even in subsequent trials. This test presents a problem for defendants because it is nearly impossible to satisfy, which often has the perverse effect of encouraging rather than deterring improper arguments. As a result, when prosecutors commit misconduct in closing argument and a mistrial is granted, they are nearly always rewarded with a do-over. Further, a retrial could be incredibly costly for a defendant in terms of both in time, money, or both. When a defendant is paying for defense counsel's fees, as opposed to being represented by a public defendant, the costs of a second trial can be staggering and financially ruinous. When a defendant is indigent and unable to post bail, he or she will likely remain in custody pending the retrial, the practical result of which is that, in many cases, the defendant essentially serves the sentence for the crime, even when the state fails to win an actual conviction. For these reasons, the defendant might not want a mistrial, instead preferring to proceed with resolution of the case by the impaneled jury rather than starting over with a new jury. In other words, although a mistrial is the only remedy certain to ensure that the prejudicial conduct will not taint the ultimate verdict, its application may unfairly burden the defendant. To make matters even more complicated, courts vary as to when and how defense counsel must request a mistrial. For example, at least one court seems to require counsel to request a mistrial first, even though, if granted, such a remedy could carry serious consequences for the defendant. Then, upon denial of mistrial, counsel may properly request an admonition jury. And if counsel first requests an admonition to the jury, he or she may be waiving the right to request a mistrial at a later time. The more rational approach is to allow defense counsel to begin with less extreme requests, such as a request for a curative instruction. Then, after consultation with the client and after considering the cumulative impact on cases with multiple instances of improper argument, defense counsel may additionally move for a mistrial before the jury returns its judgment. If counsel fails to do so, then the court will assume that he or she was satisfied with the court's ruling and curative measure. C. The risk of not objecting. As demonstrated above, the law governing objections, rulings, and remedies is chaotic. Even under the best conditions, objecting to prosecutorial misconduct can be meaningless, if not harmful, for the defence. However, the risks of not objecting may be even greater. To demonstrate this, assume that a prosecutor makes an improper closing argument. To avoid drawing further attention to the argument and to avoid the risk that the judge will overrule an objection, defence counsel makes a snap decision not to object. In this case, the defendant probably waives the right to appeal on that specific point because the trial judge did not have an opportunity to offer a curative instruction, and there is no record created for appeal. More specifically, when the defendant's appellate lawyer later complains of the improper argument, he or she will set in motion a rather bizarre legal standard. Despite the prosecutor's duty as a so-called minister of justice, the improper argument will no longer be analysed as prosecutorial misconduct. Instead, all blame for the prosecutor's unethical behaviour will be shifted to defence counsel under an ineffective assistance of counsel framework. Well, we're certainly familiar with that, aren't we? This is bad news for both the defence lawyer and the defendant. First, and rather perversely, it is the defence lawyer who will be held to answer for the prosecutor's intentional misconduct. As such, defence counsel will have to explain his or her thought process behind the snap judgment not to object to the improper argument. Often, this explanation must be given months or even years after the trial, long after defence counsel's memory of the prosecutor's misconduct has faded. Second, if defence counsel remembers his or her thought process behind the decision not to object, the court will deem nearly an explanation to have been a reasonable trial strategy, and the ineffective assistance of counsel claim will fail. Conversely, if the defence lawyer cannot remember the incident and therefore cannot testify about the split-second decision he or she made months or even years earlier, any error will likely be deemed harmless. Either way, the probable result is the same. The defendant loses and obtains no relief for the prosecutor's unethical behaviour. The news only gets worse from there for the defendant. In cases where defence counsel decided not to object to the improper argument, the defendant's appellate lawyer may also choose to pursue an interest of justice, fundamental error, or plain error type of argument when challenging the prosecutor's misconduct. One author framed the test this way: without a proper and timely objection, reversal on appeal will only occur if the outcome at trial would have seriously affected the fairness, integrity, or public reputation of the proceeding. But this conception doesn't adequately describe the near impossibility of succeeding under this legal standard, as many courts add an additional hurdle to plain error review. When the defence lawyer fails to object to the remarks when they were made, the plain error standard additionally requires that the defendant establish not only that the remarks denied him a fair trial, but also that the outcome of the proceedings would have been different absent the remarks. And yet, other appellate courts seem to imply that even unfairness combined with harm is not enough. Because these courts are highly tolerant of prosecutorial misconduct, plain error review is ordinarily limited to blockbusters and does not consider the ordinary backfires, whether or not harmful to the litigant's cause, which may mar a trial record, And if we have learned anything thus far, it is that improper argument is so common that it is ordinary. Courts therefore nearly always reject plain error challenges. The result, once again, is that the defendant obtains no relief for the prosecutor's misconduct. I think we'll stop it there. Again, it's absolutely fascinating. I mean, we're talking about in closing arguments, but I would suggest that you know, it's not just closing arguments you need to look at for the prosecutorial misconduct. Anyway, we'll hold it there and we'll do another segment, possibly over the weekend, but quite possibly, we'll wait and see. I won't say when the next one's going to be. Anyway, catch you soon. And I've got a couple of videos coming out over the weekend. I'm looking forward to inviting some new people that I've never spoken to before. So we'll catch you all soon. Bye for now.